for, okay, participation. And who will take questions? Can you guys take questions? Because I'm not very good with, I'll try, but I'm not very good with technology.
Okay.
Great.
Melina? Would you like to say something about Professor Tsesis, Melina?
Sure.
Yeah.
It's an honor to present today's seminar. I will be speaking this introduction, Alex, in English. I think everyone that is here will comprehend me. Professor Tsesis is a professor at Loyola University, Chicago School of Law. He teaches constitutional law, First Amendment, civil procedure, and other seminars devoted to civil rights. Professor Tsesis is a constitutional thinker with many articles in prestigious law reviews. Also, his books include Constitutional Ethos, which is a personal project of me and Professor Kanayama to translate it to Portuguese. It's ongoing already. Also, his books include For Liberty and Equality, The Life and Times of the Declaration of Independence. And his recent work, it's being discussed and presented here, that is Free Speech in the Balance, which from the quick review that I got, it's a theory for balancing free speech against other express and implied constitutional, statutory, and doctrinal values. It's a great honor and responsibility to introduce Alex, because he is a great professor and also a very kind person, a friend that has already been with us at 2017
Yes.
at our constitutional colloquium. And Alex is also the host of a very prestigious constitutional colloquium at Loyola University that we have the joy and honor to attend from, I think, I don't know the first year that Professor Kozicki went, because she was our pioneer,
Yeah.
2013.
Yeah.
So it's great being able to attend the colloquium, and probably this year virtually, but we will be there because it's a very prestigious and contemporary forum for our constitutional discussion. So Alex, it's very good to see you virtually here, and the word is with you.
Thank you so much, Melina. It's such a joy to be with you, and Katia and Vera, thank you both very much for this invitation. You know how closely I feel to University of Paraná, and it's a joy to be amongst you. I learn from you all, and I'm looking forward to learning for this presentation. And what an amazing thing that we're able to do this through technology now, that we're able to link up from so great a distance and to nevertheless be able to see each other and to communicate. I want to present today a book that's coming out with Cambridge University Press called Free Speech in the Balance. I expect it'll be out late August or September. I'm not sure, because things have been delayed, and so I'm not entirely sure it's going to be on time, but that's when the plan is. The galleys are already this book takes a very heterodox position, a very unusual position in the United States, and yet it's something that is well known in Europe, and that is a balancing approach to free speech. So I'm not taking a European point of view, and only one chapter in the book actually does comparative work. The chief purpose of the book is to demonstrate to First Amendment scholars in the United States that a balancing of interests that includes free speech but other values such as privacy is also possible without violating the representative democracy features of free speech in general. I take it as a foundation, and I spend a chapter on this, discussing the function of free speech. There's really a very long-standing debate on this, whether it's for public or private purposes, and third, whether or not it's for the expansion of knowledge. And I say that really free speech is for all of these things. It is for democratic values, but it also protects personal dignity, civic engagement, and the flow of information. And I show that that's a more cohesive, more synthetic way of understanding the purpose why constitutionally this fundamental right is protected. Melina, am I speaking slowly enough that people understand, or am I breaking up? Is my technology okay? Okay, great, thank you.
It's great, it's great.
Okay, great, thank you. So what you have to know first is the First Amendment doctrine as it stands, because to understand what my project is, which is to speak against the libertarian strand in American law, you have to understand what the libertarian strand in American law is. By libertarian, very simple, the court tends to favor freed autonomy, in particular autonomy in speech, above other values, above, for example, equality in matters of hate speech, just as an example. So that's what I mean by libertarian. And that's the feature of the court, not only from the right, which of course there are 4 justices who are conservative, but also from the left, because there are 4 liberal justices. But they seem to have coalesced in this concept. Whereas in the 1930s, 1940s, all the way through the 1980s, there was a large contingent of scholars and even justices, Felix Frankfurter being the main one, who's a Supreme Court justice, who believed in this balancing approach. But now it's virtually all categorical. And part of the problem that I find with this, again, before turning to what my theory is, and just to explain where I'm coming from, part of the problem, I believe, is that this gives room for judicial supremacy, where the court can simply find regulations unconstitutional by using some category that is judicially created. So it creates what some people call judicial supremacy, rather than the regulators who are elected officials being able to make decisions as to this balance between speech and other values. It really gives the power to the court. And the book is in 2 parts. The first one is theoretical, and the second is application to various different various different areas where expression is involved. So I'm going to try to do that, and I don't know how much time I'll have, but I'll do my best both to go into the theoretical foundation that I've already somewhat asserted, but also to go into the application of it. So to begin with a case that Chief Justice Roberts wrote called United States v. Stevens, a case that dealt with a review of a federal statute against animal cruelty. The court found this animal cruelty statute, and it wasn't cruelty to animals, but rather the dissemination of videos and other written materials that materially gained, they had a price tag on cruelty to animals. They were sexually explicit, very disgusting videos of animals being tortured, of people engaged in the torture of animals as a sexual fetish. The court found the statute to be unconstitutional. And for our purposes, what's most critical is that it said that all speech is protected except for a few low-value categories. And the low-value categories included such things as obscenity, defamation, fraud, and incitement. And in identifying where those values that are not fully protected by the First Amendment, in other words, speech that doesn't get the full consideration of the constitutional law, the court said that the source of these categories goes back to 1791. Now, 1791 is the year that the United States Bill of Rights was ratified. So this was a very originalist method that the court used. And I've argued elsewhere in an article and partly in the book that the court is just wrong, that categories like obscenity and other things like incitement did not even exist in U.S. law. Not even child pornography didn't exist as a category in U.S. law until the 20th century. So it's just a historical inaccuracy for the court in the first place to identify these categories in 1791 at the ratification of the Bill of Rights. So that already looks like a sleight of hand, a trick that the court is using in trying to say that it's got this foundation that goes all the way back to the founders when it's actually something that's much later. And this came in, this same categorical approach goes back, appeared in later cases, like a case dealing with a law being found unconstitutional that prohibited people from wearing military honors and falsifying their having gotten them. And another law the court found unconstitutional, where the court said that a state had overstepped free speech rights by prohibiting violent video games or children renting violent video games. These all use this categorical approach that I think is incorrect. And instead of this, what I want to say, as we know, moving on to my own approach, is that free speech should be considered part of a constitutional ethos, something that Melina mentioned as having been the subject of my most recent published book before this one. And that I want to say that the First Amendment should not be a necessary trump, should not be libertarian, but rather part of a larger schema that protects opinions, institutions, and heterodoxy. And I want to come back to that much later, hopefully at the very, very end, and tell you where I think I want to give you the strong argument, and at the very end tell you what I think is the largest weakness of my argument. But first, let me lay out the strongest argument. And so I think that the court's rigid method of interpretation is quite problematic, this categorical libertarian approach, because it requires courts to demarcate inflexible criteria that sometimes simply don't fit the case. And they have to fit this case in the categories that are existing. And that, I think, is a predetermination of decisions because it doesn't look at all of the various relevant factors and does not weigh the totality. The current Supreme Court doctrine does not weigh the totality of the circumstances. Why is it important to do so? I think it's because then it conceives litigants as individuals rather than as categories. And it's also critical to focus on the specific conflicts before the court rather than constantly trying to pigeonhole it into some category that fails to adequately address counter-arguments and often disregards conflicting legal reasons and downplays the facts of the record. The First Amendment as a normative value, then, is integral to more central and fundamental functions of constitutionalism, such as the preservation of representative democracy and the fair treatment of individuals. So for those of you who study philosophy, I actually integrate deontology, the Kantian methodology, with utilitarianism, that is to say, efficiency. So I think the function of government is a synthesis of both protecting the individual and benefiting social good, and that's and speech is critical to that. So there are many tests for balancing that have been proposed, and the one that I follow most closely is the one that Justice Breyer, one of the 9 justices on our Supreme Court, proposes, and that is that what's meant by proportionality or balancing means that you look at the interests of the speaker, countervailing government concerns, and look at the means end analysis, and are there less restrictive means of achieving the government end, and the historically relevant factors. So the only thing I want to say that there's some parts of that test are very obvious. The speaker's interest is very obvious. The second factor perhaps is not countervailing government concerns, and what's meant by that is what's the policy behind the regulation. The third one, which is means ends, which is, is this law, the provisions of this law, do they really, are they ones that are likely to achieve whatever is this countervailing end, policy end that's meant to achieve? And less restrictive is the government trying to suppress speech beyond what's necessary to achieve that end. And I do think history is relevant. I mean, ultimately, each of our countries is unique, and free speech is not some Platonic abstraction, but something that it has some history behind it. I think that also has to be considered and should be considered in all cases that we can. And ultimately, balancing is not entirely relevant. Is not entirely novel, is not entirely new to First Amendment United States jurisprudence. And I go through numerous examples of that type. I'm not going to spend time on that because we just don't have the time. And I would rather just lay out some critical points at this point. One is that the Supreme Court of the United States has become increasingly libertarian. And so, for example, in a case called Reed v. Town of Gilbert, the court found that signs, I mean, literally signs, like things that are put on, you say, if you want to go to the church, it's on this street, on the corner of this street and another street, that even that is protected speech under the First Amendment. The court said that even restrictions on what I can say on a sign, and specifically directions of where my church is. This was a church that met in different buildings, and it challenged this law. So some days it was in the library, some Sundays it went to a school, and they wanted to tell people where they are, and there were different restrictions for it that limited it more than signs that spoke about politics and ideology. The court said, oh, no, that's protected speech to the fullest extent, and all speech is protected to the fullest extent. For those of you who studied U.S. law, that it deserves strict scrutiny. You have to prove that there's a compelling government interest and that there is the least restrictive method to restrict that speech. So extremely high requirements that are almost impossible for the government to meet. And Justice Kagan, in the dissent to that case, pointed out that no, there are many signs that are not at all protected by the First Amendment. And she's talked about ordinary police signs, such as speed limit signs. I mean, things that I'm sure are true in Brazil, just as they are in the United States, and don't get strict scrutiny. Road signs, address plates, historical markers, this famous person lived here. I mean, the government can say, we can have this placard, or, you could say the size of a street sign will be this, and the sign of the stop sign will be that, and without having any First Amendment issue. In other words, Justice Kagan, in her dissent, pointed out the reductio ad absurdum of the court's argument. It doesn't make sense that all speech is protected exactly the same way. And so in the pages of the book, I argue that courts should evaluate whether speech plays a central or peripheral function by specific legal disputes. Communication enjoys the greatest protection when it furthers a well-ordered representative democracy whose function is equally protected individual rights for the common good. And here I'm sure Molino and Rodrigo will hear echoes from my previous work. Adjudication requires exacting information about speech involved, any countervailing government concern, pertinent experiences with similar speech claims, alternative means of regulation, and examination of whether legal means chosen are likely to achieve that public end. And that is a value-rich perspective on free speech. It is not a categorical approach. It takes very significant fleshing out of all the legal and the factual concerns. Whether a particular judicial decision on free speech is consistent with the value of deliberative democracy should be judged by synthetic considerations of the authoritative texts, that is to say, in democracies like ours, written constitutions, but also abstract reasoning, because when we consider such things as representative democracy, individuality, equality, there's obviously a large amount of abstraction, not philosophical abstraction, but legal theoretical abstraction, but also civic and pluralistic principles, doctrinal reflections, informational values, and rational applications of existing laws. Categories are useful synthetic starting points for analysis, but they should not be the end all, because behind judicial categories, which I spoke at the beginning of, are principles of constitutional governance. So, for example, to take one example, it's not in our Constitution, and that is antitrust laws, anti-monopolistic laws that prohibit anti-monopolistic practices. They take for granted that there is a power in Congress, in the legislature, under the Commerce Clause, involving cases that can prohibit monopolistic conspiracies, but that communicating insider information, that is, say, if I know things that will benefit me because I have special information, are not protected by the First Amendment. And these are value rich. It's not just some arbitrary decision. So I don't know about the Brazilian Supreme Court, but in I doubt, in fact, probably the same as in the United States, there's no Supreme Court case that says, well, you cannot share insider information because that is not protected by the First Amendment. And yet it's just taken for granted. And I'm saying it's value rich. This is a balancing matter rather than something that's simply taken for granted. And we should be honest about this rather than, as the court, try to say all values are identical whenever it comes to speech. Often a variety of constitutional provisions come into play. In deciding challenges or regulations, judges should not limit their analysis to First Amendment and free speech as trumps. They should rather review facts based on constitutional provisions relevant to the resolution of legal disputes. And conflicts are inevitable between values of speech, safety, privacy, intellectual property, national security, education, and many other matters that are during litigation. So I'll give you another example. We have a law that the court recently found unconstitutional. It was a California law that the state of California, one of our 50 states, required pregnancy crisis centers to carry a message. This message simply said that there's free medical care available. And where the pregnancy crisis center was unlicensed, it had to say this government-sponsored message was, this is an unlicensed facility. The reason was that many of these crisis centers, over 95% of them, I don't know the exact figure, but an enormous amount of them, almost all of them, were religiously driven, and they tried to talk women out of abortion. Well, the government wanted women who came to these crisis centers not realizing that they were stepping into these ideological forms, women who wanted medical advice, to know that there was free medical advice that the government could provide for them. But the court said that's an unconstitutional to compel these crisis centers to have that viewpoint. But to me, that uses free speech as a trump. It says it's a message, and therefore automatically other considerations, and this is in the United States, we say a woman has a constitutional right to privacy, that it doesn't get the same level of balance. It just is automatically speech as something that's greater. However, the outcome of that case, there should have been a greater balancing of interests. So contrary to the Supreme Court's often repeated claim, as I mentioned in this case called about signs, Reed versus Town of Gilbert, not all content-based restrictions on speech require judges to engage in the highest level of review. Weighing free speech against other values goes against the commonly accepted grain of the United States. I expect to get either this book will be entirely ignored or this book will be constantly argued against because it's so out of the mainstream of U.S. law. The U.S. scholars typically argue that proportionality review remains fundamentally subjective. That's the problem they find. They're afraid of subjectivity from judges, and that it does not create a workable judicial oversight. So, for example, David Cole, a very well-known First Amendment scholar who is now the head of the legal section of the American Civil Liberties Union, also a professor at Georgetown, David Cole, argues that balancing is too open-ended and unprincipled. Cole warns that proportionality standard will provide little in the way of principled guidance. And another well-known First Amendment scholar, Martin Reddish, argues that balancing can suppress viewpoints. And to some extent, of course, Reddish is correct that ordinarily only real threats to society will suffice to curtail information. But that criterion does not explain the limits on speech, such as defamation, fraud, contract, why we limit speech on contract. We make certain requirements, and it has nothing to do with constitutional values of free speech. The question is, how do we explain that? And my point is, we cannot explain it any other way except for valuation. We can say, of course, well, these are categories that existed in 1791, but it's just not true. Fraud was a category in 1791, but certainly not others, such as antitrust and obscenity. So in a transitional chapter, I talk about foreign guidance. As I say, I didn't spend a whole lot of time on it because it would obviously require an entirely separate book, and frankly, I'm not an expert in it. But I did think it was important to compare it to EU law, and particularly the European Court of Human Rights. And so my focus is on opinions dealing with this balance or this conflict, I should say, between privacy and free speech. What do we do, particularly, for example, with social media, where there is a conflict? I want my privacy kept. Someone else wants to express herself and to use my information, maybe photographs at a party or whatever it may be, to express herself. Robert Alexie, the most famous of the European proportionality scholars, pointed out that many constitutional courts engage in balancing weight. In turn, the scholar has accurately asserted that constitutional courts all over the world have adopted Alexie's principled theory of proportionality. So the European Union regards free expression to be among the preconditions of functioning of democracy in the same way as the United States does. And yet Article 10, for example, of the European Convention on Human Rights is a protection of the freedom of expression for everyone to hold opinions and to receive and impart information and ideas. And yet Europe believes it can remain a healthy democracy with balancing, and where the U.S. says it's not feasible without having these categories. So there are a number of well-known cases, for example, coupled with Princess Caroline, where she wanted part of her life to be private, and tabloids wanted to publish, her in various parties in various places. And she said, "Look, I want to be a private person." And they said, "Well, you're not a private person; you're a princess." So the European Court of Human Rights found, particularly in the second of these cases, one was in 2004, one 2012. This is the later one, that photographers had created a climate of continual harassment, which could induce her and other people to be very concerned about a strong sense of intrusion into their private life, and that on balance, the court favored in both cases, whether in the 2004 and the 2012 case, that the privacy. And they said that the way that they would balance it, this is not my test, but a more European test, is that they would look at the work's contribution to public debate, how well known the person is, and any prior conduct. In other words, does the person try to be public in some of these ways? The content and the form, and notice how different this is. The EU, European Court of Human Rights decision is in America, right? Where in the United States, content automatically gets these heightened free speech rights. The European Court balances it out. And this isn't only true just in this Princess Caroline case. It exists in another well-known case, Delphi versus Estonia, where the court said even penal severity, that is a prior criminal conviction, could be something that on social media, not to take it out of the public information realm, obviously, not from the public record, but that that privacy could be considered even this past criminality. And then another case called Einerson v. Iceland that I discussed, a well-known person was subject to reporting, but the court said there had to be a balancing. That is to say, look at the contribution to public debate, the subject of the report, prior conduct, method of obtaining the information, right? Was information obtained in some clandestine way or not? And so the remainder of the book goes through a variety of applications to this law, to this methodology. I'm almost out of time, so I'm going to just give some examples. I talk about a variety, each well, I should say not entirely each in a separate chapter because there's some overlap, but I talk about such things, applying my theory to such matters as hate speech, incitement, terrorist speech on the internet, free speech on college campuses, speech in the setting of classrooms, that is to say, in speech in the United States is protected even in high schools and grade schools, but not insofar as it creates a substantial disruption to education. And I say, well, that's also balancing there. So I apply the doctrine to that. That's a particularly interesting area because more and more schools are limiting children's ability to communicate, even when it's off campus, even when they're, playing around and it's off campus, but on social media. And the final thing I want to close with this example and then tell you the weakness, which I promised to tell you, although it's probably already very obvious. So I want to say something which is probably the greatest consequence of this doctrine, and that is the United States Supreme Court, because it says all speech is the same, this is translated in the way that extremely affluent, rich people use their money for campaigning. Donald Trump could not have come to power if there had been some limitations on speech. If the court said that the appearance of corruption of a very rich person using all their wealth to get elected can be limited without it being heightened to the level of free speech protection, and that then Congress could have limited it. And in fact, there were laws on the expenditure of money in 1971, and the court found that was unconstitutional in a case called Buckley v. Vallejo. And now corporations can fund campaigns to an unlimited, to expend money on campaigns to an unlimited amount. So contributions that are under the control of the campaign can be limited, but although the court has expanded even speech there. So without any sort of weighing of representative democracy as opposed to a person's desire to let me say anything I want to, I'm Donald Trump, or whomever it is, it could be, Obama, anybody, that this really creates a situation in which communication can trump all other things. So I'm going to stop with the theory there, and the very obvious weakness of all of this, and it should have come out because I was talking about counter arguments with Marty Reddish and David Cole, is this potential of subjectivity and the potential of autocratic states to abuse this weighing, to stick in judges who use weighing as a way of suppressing speech and just say, well, the government's position outweighs that of the speaker, and then to have a suppression of speech. And so with that, I welcome your comments and advice.
Thank you very much, Alex, for your presentation. I think we could open to the debates. We usually go with a group of questions, maybe 2 or 3. Then I give you the word to the answers. It's okay if we proceed like that? Okay. So I don't know, Professor Ronaldo would like to start with his question, and then we go 2 more, and then we go back to Alex to his answer. Professor Ronaldo, please.
Alex, it's a real pleasure to be with you and to discuss such an interesting and such a contemporary issue, which is free speech and balancing. As you probably might know, Brazil is usually adopts proportionality tests in dealing with free speech cases. And in my opinion, and let me be very frank, this is a really misguided way to deal with freedom of speech cases. But my point here is, of course, what you have called the categorical approach can lead to a mistaken analysis of free speech cases, especially because once you characterize this approach as categorical, and in a way you also mentioned and criticized some way the way by which judges usually understand this categorical approach, which is somehow mechanical in the terms that it tries to create a kind of dogmatic protocol in order to deal with free speech cases. What it usually misses, but not all the time, this is controversial, I know, but what this kind of, let me call it dogmatic, doctrinal approach to use in dealing with free speech cases tend to give little importance or underestimate the relevance of conceptual analysis that lies behind the analysis of free speech cases. In a very, let's say, caricature of how things usually are taken in Brazil, people usually take, let's say, for example, some years ago, a judge prohibited the selling of the book Mein Kampf from Adolf Hitler in the city of Rio de Janeiro, and she argues that, well, free speech should be balanced with the principle and the value of human dignity, and so what was she saying in her decision? She was basically saying that both concepts and both values, freedom of speech and human dignity, should be understood on their let's say conventionalist meaning, what is usually understood by these 2 concepts. However, what could be counter-argue for this kind of understanding of this kind of, let's say, rapid jump into proportionality tests and somehow kind of ad hoc balancing of what is more important, human dignity or freedom of speech? We could counter-argue that we cannot protect human dignity if we do not protect free speech. So it all depends on how you understand the very meaning of this concept. So some kind of, let's say, conceptual analysis of these concepts that are involved in this, let's say, this struggle requires a lot of philosophy, a lot of political philosophical discussion on how to understand the very concept of human dignity, on how to understand the very concept of freedom, and how to understand the connection, or maybe the possible clash, but it's not a necessary clash, between freedom and equality, for example. So this, in my view, requires a lot of interpretation, of philosophical interpretation. So it's unavoidable to deal with these things. And when we think about Robert Alex's methodological approach to dealing with balancing, especially dealing with free speech, what is assumed, what is a kind of presupposition of his analysis is the fact that he takes for granted a conventionalist approach about the meaning of the major concepts involved in this analysis. He has to accept some kind of a priori, for example, hierarchy between theoretical hierarchy among these values, which comes together with accepting that the best way to understand these very concepts is as if they were necessarily clashing, as if pluralism was a necessary departing point of analysis. But why should we accept this? Why should we not try to adopt, or at least make some effort in a different approach, an approach like more Rawlsian or more Dworkinian in spirit? So this is my major point. Of course, we could cite many different cases that let's say, in the American case law were decided mechanically. And we can also make the same kind of effort and try to find, and we could also find some kind of mechanical analysis of proportionality tests. And they're probably both wrong, and they're probably both reductionists. But at the end, I think there's an important methodological divide on about what is the best way to understand the processes of balancing, either as proportionality tests or maybe as a balancing in a meaning more close to what John Rawls or Ronald Dworkin have developed. And finally, I think that, well, swimming against the tide, it's a very good opportunity to in a way, a very good recipe for academic glory, especially in the United States. You shouldn't be afraid of it.
Professor Vera, our dean.
For 20 more days, and that's it. And the deanship will finish. Well, thank you so much, Alex. It's always amazing to listen to you. I kind of agree with Ronaldo, and I have a more philosophical question. Let's put this way. From my point of view, Robert Alexis' balancing theory is very much subjective and somehow irrational. So how do you manage, like, to part from a theory like Alexis' proportionality theory or balancing theory, having in mind tests such as the strict scrutiny, how to put together? I can't see how to do it. Besides, for Robert Alexis, constitutional review complies with the requirements of democratic legitimation to the extent that it succeeds in becoming an argumentative representation of the people. So how can I take this point of view and applies to the US Supreme Court tradition or procedures? That's it.
I don't see anyone joining this group of questions, so I would like to join, if Alex allow me, to one final question in this first group. There is this idea of free speech. There is it presupposes the idea of a tolerant society that embraces the right of the speaker and the right of the audience too. And of course, as you stated, those are not absolute rights. They have constraints. And I think the constitutional ethos, the liberal equality for the common good, is an important one. But this notion is, I think, very proper of the North American constitutionalism. I don't think we can just shift this idea of liberal equality for the common good to other constitutionalisms like Brazilian. So if we have to think in contextual components to justify these limitations for the free speech, if we don't have these ethos, if we don't have this strong notion of liberal equality for the common good, what do we put in place to justify this contextual component that could constrain or limit the free speech?
So much. I really appreciate it. I learned just from listening to all of you. I will try to go quickly, which if I knew that there were no more questions, I could go slowly, but not knowing who else is coming and wanting to get as many people as possible, let me try it. I would be very interested, first of all, going to Ronaldo's points and answering everything in the order we got them. That's very interesting to me about the Brazilian balancing. It'll be very interesting. I think the thing is that while there is a lot of potential for corruption with balancing, the same is true with categories. So, for example, the court uses this, the last case, this case called Citizens United, which is quite famous, Citizens United, where the court said corporations have the same free speech rights as do persons. Well, that comes out to a very specific conclusion. And then Becerra also says, well, we won't balance the values and therefore that'll reduce the subjectivity. But Becerra comes out very anti-abortion. And other things as well. There was a recent case where the court said that it would not balance, and it was about the state law that said that there had to be a listing by the cash register when people checked out and paid money, and it would say, you're paying more money if you're using a credit card. Well, the shopkeepers didn't want that information. The consumers wanted that information. They wanted to know whether they should pay cash or by credit card. And the court sided with the companies, with the sellers. The same is true in a case called Sorrell, a case where the Supreme Court found that we have a state called Vermont law that prohibited the sale of records about prescriptions, that was unconstitutional. The court said pharmacies can sell information as long as it's anonymous about what drugs doctors are prescribing, and that restricting pharmacies from revealing that to big pharmacy companies that want people to use expensive drugs was a suppression of free speech. So I very much take it to heart what you're saying, and I am certain, I share your same worry, and I share it about my own work, Nietzsche came up with some really good theories, but they sure created a lot of problems that he never would have wanted to create. So all of us are in this position where we get a lot of ideas out there, and but it's impossible to overcome the holes. The question is, what's the best method? It's not that Plato ever brought Nazism in. The problem is the misunderstanding and misinformation. Can we make this as airtight as possible so there isn't abuse of autocracies? It's not wholly possible, but at least if there's transparency, then at least we get a full airing out of what it is that the judges are doing in evaluating all these interests, rather than just saying, oh, it's just obvious. Of course, it's speech and that trumps. And then the second one is that categorical approach underestimates conceptual reasoning. There we certainly are right. The Mein Kampf example is very complicated, and I think in the abstract, certainly that if you just balance dignity and speech, I agree with you. We come up with which is stronger, dignity or speech. Will I say dignity, you say speech, or vice versa? Who knows? So that there has to be more. And if we look at the historical aspects, that is to say, I'll give you another example, better than Mein Kampf, which is even more complicated. That is to say, Martin Luther. Martin Luther has a book called On the Jews and Their Lies, in which he says, burn all synagogues, don't let any rabbis teach, burn all their books on pain of death. Well, what do? Do we get rid of Martin Luther's writing? Of course not, right? It's again, context. If it's being used to teach history, if it's being used to evaluate what's there, why this did come into Nazism, because there's a much more obvious reason why Martin Luther came into Nazism than Nietzsche, who hated anti-Semites after all, and wanted all of them to be shot. Then we will get better understanding why, when Mein Kampf is a historical document, then it is protected. It's not violating anyone's dignity, but where it's being used to inflame and to gather people who are like-minded, then there's something that's very dangerous. Freedom and equality mentioned, very important. And the Alexi point, and this goes into Vera's point immediately, that of course we do need to use Rawlsianism and Dworkianism, although Dworkin of course was against speech limitations. Rawls more or less so in the liberal society. Tolerance is absolutely critical. And I agree with both of you that, Alexi has a subjective theory, that because of that we will need judicial review, right? That's something that allows for it. I have an article that I've just written about trying to deal with these situations where there are differences in values, which are inevitable. It's not only inevitable between us individuals, but also inevitable where there are state actors. And I want to argue that it depends on who's expanding rights, and where they're expanding rights, that should be the more weighty concern. Now, that's not satisfactory either. Because, okay, so one person says, I'm protecting women's privacy rights, and the other judge says, I'm protecting speech rights. Okay, well, now we have one, it's not just one is abridging rights against one is expanding. We have two of them that say we're expanding rights. So it's a very complicated matter, but it's still weighing, I think, is the most transparent, most analytically expansive. It allows us all to discuss and consider it. And where the legislature to say, we don't think you balance these values correctly, and representative democracy, we're going in a different way. Now, going to Melina's, and I'm sorry if I probably talked too long, with Melina's point that, I think that all societies ultimately have to protect the common good. That is to say, where if even one of us is harmed, it's not a utilitarianism in a Benthian or even a million type of view, but rather one where if even one person is enslaved, we're reducing the common good of the whole. So that we must be, well, if women are suppressed, that does not benefit men. In fact, it reduces the talent pool in society, but by more than 50%. And the same is true as even if one is being oppressed. If we have one person of an indigenous group is the only survivor, if we steal from that person, all of society's values are suppressed. I have a lot of arguments on that. I just don't have the time. And I think that so that this is a concern for individuals and the common good. I'm going to stop here just in case there are any more questions.
Yeah, with Professor Miguel Godoy.
Okay, thank you, Professor Tsesis. First of all, it's a pleasure to hear from you in this meeting. So I would like to thank you for your speech and this Q&A. I would like to hear from you, what's your opinion about the Facebook's oversight board about free speech? Will this debate about balance be taken into account or be important to evaluate its work on free speech in this new kind of private court about free speech?
Melina, should I wait? Are there any questions?
Yeah, we have Guilherme.
Good evening, Professor Tsesis. It's a pleasure. My question regards the use of foreign law by the American constitutional law. And do you see a political environment that is supportive of that practice? Because when we think about balancing, mainly we talk about as a transnational concept, right? We compare different decisions and takes about freedom of speech elsewhere. How do you see it under the current environment in the US? Thank you.
Also, Professor Kanayama would like just to make a comment.
I'd like to thank you to Alex. Hi, Alex. How are you? I'd like to thank you, Alex. Your speech is excellent. I like so much. And actually, I was searching your book, but I saw that to be launched only in some months, I think. And I hope that we have a Kindle version because it's easier for us. But I'd like to express my congratulations for your research, just that. And I will send my questions by email after. But I'd like to thank you for your presence.
So first of all, let me just respond to Rodrigo. I'm so deeply grateful for all of your friendships. And I look forward to making the acquaintance of those of you whom I don't know. But you've really enriched my life so much by these conversations and by our interactions that I should be the one who is giving the thanks, and I certainly feel it. So let me say a couple of things. First of all, going into Miguel, I am concerned about the Facebook board, and this I know several people on it. As it come to mind are Pamela Carlin and also Jamal Green. I mean, they're very, very wise people, but I think that it will not really get off the ground. I think that it will not go very far. The reason is that there is no indication about who appeals, what are the procedural rights. There's nothing about procedure at all. Can you have an attorney? Is there something for advocates? Can you get a record? There are all sorts of questions about the judiciary system that's been built up over the course of thousands of years that just don't apply in this private setting. So I'm very skeptical this will get anywhere. Also, it's the Supreme Court. Where are the lower courts? And how many levels of the review are there? Is there en banc consideration? I mean, it's just, what about standing rules, mootness rules? Can they give advisory opinions? Some countries you can, of course, in courts. Some countries you have to have a rule in controversy. It's unanswered. So it's so premature. I can't. Will courts honor their decisions? I doubt it very much. So I'm surprised it's gotten as far as it has, and we'll see how things go. I would, in fact, maybe after I stop speaking, Professor Godoy, maybe you can tell me what you think, because maybe I'm curious whether I'm far more skeptical than others of this. And then Guilherme, so U.S. Cases have increasingly used foreign law, but in my opinion, not nearly enough. I think there's a tremendous hubris, a pride amongst American jurists, particularly and especially Supreme Court justices, that they think that they're the best Supreme Court and they don't have to listen to anybody else. Now, they would obviously not say it that way. What they would say would be that there is Rodrigo, thank you for bringing in your baby. And Melina, I saw your baby, or your daughter earlier on. Thank you. One of the joys of this Zoom. So that we are seeing more foreign law in cases like Lawrence v. Texas, a case that recognized the privacy rights of gay and lesbian couples to sexual intimacy. And we saw it in some other cases, but there's very little of it. And it's so incredibly disappointing because European courts, and Brazilian courts, Canadian courts, amongst the ones that I know, will use U.S. Supreme Court cases quite extensively, but it's almost like U.S. courts think that they aren't adequate. Of course, the defense U.S. jurists would say would be that these countries have different histories than ours, different precedents than ours, different systems of stare decisis. But I think it's disappointing that not more is made as advisory opinions, obviously not as binding opinions, but at least as advisory opinions on issues such as hate speech and issues about social media and privacy that the U.S., I think, for example, does not look adequately, does not give enough weight about the history of incitement and racial incitement and ethnic incitement, religious incitement, and the harms that it has produced. The U.S. has this very neutral approach to it that is based on a philosophical social Darwinism going back to Oliver Wendell Holmes. And I think we should use foreign law, jurists should use foreign opinions and their sophisticated rationale more. And I think that could definitely go into the balance.
Thank you, Alex. it was a delight to hear you and to learn from you once again at this webinar. I will now hand the word to Professor Katia Kozicki, who was very kind to invite me to host this seminar. And for me, it's, like I said already, it's an honor and a joy, because I am not only fan of your work, but also you are a dear friend of ours. Thank you.
Thank you. It was a tremendous honor to me. Thank you so much for everybody. Thank you for joining me. Thank you for taking the time to listen to my ideas. I'm deeply grateful to you.
Melina, thanks to do the honors. Alex, thank you so much for joining us tonight. It's very good to see you, even if it's virtually. And even so, we all prefer to go to Chicago next November, like always. I'm obliged to say that we can go there, but through Zoom this year. As you know, the US borders are closed from Brazilians, and I don't think that it's going to change in a short period of time. So we will be with you and other colleagues at this year colloquium in November. And thank you very much. And
thank you. And you will often be in my thoughts, just so you all know. If walking around the day, know that you are in my mind.
okay.
Alex, go ahead.
Now, before finishing, I'd like to make an announcement that we are going to have Professor Chantal Mouffe next week's seminar on Tuesday, 11 a.m. this time, because of the time zone difference. I hope to see everyone next week. Everyone?
No, just to tell Alex that because of the set of songs that he kindly to me at this time, I'm relaxing because of your kindness.
What a joy. What a joy to know that.
Alex, last year when I was in Chicago, I went to a bar called Rose's Bar. I have never been there before, but it's a very good bar, jazz bar. Rose's Bar.
Rose's Bar.
I was hoping to go there this year again, but maybe
I can
next
make other
year.
suggestions. When you're here, we'll make other suggestions for blues bars and jazz bars.
Okay. Thank you.
Okay. Thank you. And I will see you all soon. Thank you so much.
Yeah, thank
Bye-bye.
you. Bye, Alex. Take care.
Thank you, Alex.